As has become our practice over the last number of years, we use this annual meeting as a time to present lawyers matters that are of vital importance to the profession. It's trite to say that none may be more important today than the issue of access to justice, for it not only impacts us, but is a matter of broad interest to the public. It's also of interest to the courts, to government, to all Nova Scotians. We are honored to have with us Dr. Julie MacFarlane, Professor of Law at the University of Windsor and at the Kroc Institute for International Peace Studies at the University of Notre Dame. The title of Dr. MacFarlane's address is, Does Access to Justice Equal Access to Legal Services? New Questions and Answers from the 21st Century Clients. So I'd ask you to please join me in welcoming Dr. MacFarlane. What we're going to do is spend about 2 minutes of awkward silence while Dr. MacFarlane puts up her presentation on the screen. So if you need to get up and stretch, feel free to do so. Don't go far.
Room. It's sort of like walking into a sauna this morning. So, yeah, I hope everybody's comfortable. We've lost a few people here, but I'm assuming they're going to trickle back in. So I'll get started, shall I? Do you want to do a little? Yeah, they can sit in the other room too, so. Okay, first of all, thank you so much for inviting me. It is always my privilege to go to another part of the country to meet lawyers, to talk to people in your law society governances, and to find something else out about the constantly changing landscape of legal services in Canada. And I had a fascinating day yesterday working with the Society and some community partners around your strategic planning for access to justice, which is the theme of what I'm going to speak to you about this morning. And that also was a great opportunity to find out more about what's happening here and to, if you like, try to really hone my remarks this morning so that they feel as relevant as possible to you here in Nova Scotia. Because although every part of this country, and for that matter, every part of the United States, is experiencing seismic change in the ways in which lawyers are thinking about the delivery of services. Every jurisdiction has its own particular foibles, idiosyncrasies, etc., and so I will do my very best to honor those today in my remarks as well. What I want to do this morning with you is to raise what I'm calling 5 urgent questions. And although this will come as a great disappointment to you, it will probably also be no surprise that I'm not going to provide you with the answers to the 5 urgent questions, but I am going to suggest to you some of the ways in which you are going to need to start to think about answering these questions. I am tremendously impressed by the commitment that the Society has made to enhancing access to justice for Nova Scotians, and I was very, very encouraged by what Renee has just said about grasping the nettle of the scale of change here. You know, those of you who know something about my work probably know that I have for many years now been researching and writing and talking about changes in the legal profession, but I think never have they been more urgent and more pressing and more right on top of you than they are at this particular moment. And this is a time that we could flee from that because change is difficult for everybody, for all of us, or you could grasp this as an opportunity. And that's very much what I'm going to be encouraging you to do today. I also want to just say by way of introduction that I know that for some lawyers, the idea of access to justice, because we see this in our law schools too amongst our students, it's not their bag. That's something that people who do that pro bono stuff do. It's something that people who work in clinics do. And what I would encourage each one of you to think about this morning is that access to justice actually is an urgent question for every single one of you. Whether you work in a large private firm, whether you're a solo practitioner, a government lawyer, an in-house counsel, every single lawyer is affected by this issue now because we have a clearly documented failing faith in the legal system in Canada amongst the general public. we have growing skepticism and cynicism about being able to access justice, which is not just about poor people. It's about the middle classes too. And so I would urge you to think of access to justice as your bailiwick, as well as those who may be associated with more traditional pro bono practices. Yesterday, one of the things that the strategic planning group came up with in struggling for a definition of access to justice was meaningful and timely resolution. You notice the word resolution, not outcome. And you notice I haven't got the word just in that sentence. Meaningful and timely resolution. And meaningful and timely resolution of client problems is a challenge for every single lawyer, no matter how you practice and what you practice. So, 5 urgent questions that I'm going to try in a very short space of time to not answer, but at least unravel a little and have you think about. First of all, how far can a public adjudication system provide access to justice? It's time that we ask ourselves that question directly. To whom and for what types of conflict? Does access to justice, and this is the title of my presentation, mean access to a lawyer or legal services? And let's face it, for as long as I've been a law professor, which is 30 plus years now, it has been assumed that access to justice means access to a lawyer and to legal services. That, I'm going to suggest to you this morning, is changing. What is our responsibility to those who cannot afford to pay for legal services? And again, let me emphasize, and I'll give you some data in a few minutes, this is not just the poor any longer. The study I just completed with self-represented litigants in family and civil court includes a subset of lawyer self-reps who tell me they cannot afford themselves. And there may be some of you in this room who would second that. How far is access to justice achieved by access via technology? We've heard a lot, and we continue to hear a lot about the promise and the potential of technologies, and they do have them. But I'm also going to raise a few words of caution there. And finally, what is the role of other professionals in providing legal services? I can hardly believe I'm standing in front of a barrister society uttering these words, but I am. What is the role of other professionals in providing legal services, and how should lawyers collaborate with them to ensure access to justice? So, a couple of initial remarks from my own and the research of others about 21st century clients, because what we have to, I think, continuously come back to answer those questions is what are the needs and expectations of 21st century clients, not only domestic, not only corporate, but all clients, and how are they different? And they are significantly different than they were a generation ago. The knowledge revolution, access to the internet, what Rene was speaking about in his address to you. This has completely changed the ways in which people think about professional services, not just in law. We know that people go and Google their legal problems now. And the information that they get as a result may be completely unreliable. They may be unable to know how to apply it. But you know, that really doesn't matter as much as their perception that what they are getting is information that otherwise comes at $350 an hour. That is their perception. There is a self-help revolution, also based on that access and the sort of removal of the traditional gatekeepers, if you like, to professional knowledge, but also driven by an increasing desire that we see across all sectors in law amongst our clients to participate, to be part of the action, to be part of the decision-making. Over the last 15 years in which I have been doing studies with the clients of lawyers and now with unrepresented people, they tell me consistently, I didn't just want to be told what to do. I wanted to be part of the action. Declining professional deference. I always say that my parents, who were middle-class Brits, would never have dreamt of doing anything that involved going to court without a lawyer, and they wouldn't have had the money necessarily to afford a lawyer, but they would have sold the family car, the family dog, you name it. They would never have dreamt of doing such a thing as putting themselves forward in the place of a professional. This is different. This has changed. There is a concept that sociologists, because they're so great at making up jargon, call disintermediation, which basically means taking out the middle person. This is why some people spend time, terrifies me, but spends time investing their own financial resources without the middle person assisting them as an advisor. This is why people sell their own homes now without a real estate agent. They believe that that is not something that they necessarily should be paying for, because this desire for value for money and transparency in where that money is going is qualitatively different than it was a generation ago. You know, I did a study, some of you may know about a decade ago, with collaborative family lawyers and their clients. And one of the things that was fascinating and ironic about that was that in the process of empowering their clients, the collaborative lawyers also ended up with more questions and challenges about their bills than they had ever had before. So these things go hand in hand, and we have to recognize that that is another big part of the change here. And I think that in terms of transparency, lawyers are still at least a generation behind where their clients want them to be in terms of transparency. An increasing desire for participation. Those of you who serve corporate clients know that increasingly corporate clients want to be part of the action. They don't want you just sending them an update every 6 months or so. I did a study with commercial litigators also about a decade ago now, and one of their most frequent complaints was, you know, it used to be so nice and peaceful having a commercial client and litigating on behalf of them, because I just send them a report every now and again and tell them what was happening. Now they bug me the whole time, asking me, what's happening? Have we thought about settlement? Why are we paying for 20 days of discovery? Questions, participation. These are different clients. We have to be able to respond to them. We also have, I think, a serious risk of having oversold ourselves in relation to access to justice, which we need to try to figure out a way to reset this particular button amongst the public. Here are some comments I've heard in the last, very typical comments I've heard in the last year from people representing themselves. No more fairy tales about having an access to justice system. This is one of my personal favorites. The courthouses are like false front buildings, like at Universal Studios. They're supposed to help you, but they don't. Now, of course, there are many people in those courthouses working extraordinarily hard to help people, but there is a disconnect between people's expectations and what can actually be offered to them, which is fueling enormous amounts of cynicism that we need to take seriously. So here's a comment from, I also interviewed over 100 court service providers. People get information from the website. There's that promise of technology again. They show up at the courthouse with expectations of access to justice. And they do, I know, because I interview these folks. They imagine they will have everything done for them. So they want to be part of the action, but they don't realize just how difficult it is to actually drive this forward on their own. Finally, they think they can do this because we claim there's access to justice. BS. So, let me go back to my questions and try to say a little bit about each of them in turn. And I hope very much I'm going to have some time for some questions at the end of this. First of all, how far can a public adjudication system provide access to justice? To whom and for what types of conflict? We still have a model which is effectively an adjudication model. Everything that we do, whether this is in family, whether this is in civil, or of course on the criminal side, short of a bargain, is preparation. It is rehearsal for adjudication. That concept drives the entire system. Yet we know, and have known for some time now, that almost everything doesn't actually go to that final stage performance. 90 to 95% of cases settle before they get adjudicated. Yet the system is still oriented, and your work is still oriented towards that preparation, that rehearsal for something that might not actually happen. In the process, we follow rules of procedure which are, let's be honest, arcane, complex. One of the comments that I heard that stands out in the last year from self-represented litigants, over 50% of whom, I should say, had a university degree, and many of them had master's degrees, was this is a process that makes smart people feel stupid. And I think that there are lawyers who would agree with that also. And then there's the matter of cost. Even those who can afford the costs are drawing back from those kinds of expenditures. We're seeing a huge rise in the number of in-house counsel as corporations begin to take work in-house so they can control costs in a different kind of way. We also have to remember, I think, that when cases come to court, even brought by clients who can afford them, they are still being publicly subsidized. This is a public adjudication model. And I think that should give us pause for thought about just how much public there should be around assisting people in the resolution of their conflict, and whether that assumption should always be adjudication. Now, setting aside criminal trials and representation for defendants, when there's an unfair dismissal claim being brought by a worker who alleges that they were fired because they were sick, should that person be guaranteed representation, be guaranteed adjudication? When two parents are fighting over access, should those parents be guaranteed adjudication, be guaranteed representation? These are very, very difficult questions, but we have to make choices here. And another way in which we might need to make a choice is to think about, why do we assume that every case is going to ultimately go forward with the hope of adjudication? Maybe only certain cases need to go forward with the hope of adjudication. And if so, which cases would they be? What do we do with those other cases? We put more and more of our resources into what we know through innumerable program evaluations now throughout North America does help to resolve and remove cases from the docket. More neutral evaluation, more mediation, more judicial settlement conferencing. These are all things that you do here in Nova Scotia, and we know that these can start to reduce the number of cases in the docket. So I would say to you that part of what we need to do here is to think about what clients really need, and whether some of those clients who are going forward into a public adjudication model actually need debt counseling, or really need family therapy, or really need a parenting plan, and how far we're stuck on this idea of adjudication, publicly funded adjudication. Next question. Does access to justice mean access to a lawyer or legal services? There is an affordability crisis in Canada. One of the things that I did not expect to find in my study was that more than half of the people whom I interviewed had had a lawyer and ran out of money to pay for them. I wasn't expecting that. This also means, by the way, that it is likely that the data that we have on how many people are self-representing, which is usually collected at the time of filing, is probably an underestimate, because so many people lose their lawyers later on. Consistently, what I heard, and this is, I think, a very important way of challenging the stereotype we've held for so long of people who are crazy to imagine they can represent themselves, is this. It's not that I think that I can do this better than a lawyer. It's not that I really want to be here doing this. I would like to have a lawyer. I can't afford a lawyer. And many of these folks have already spent $20,000, $30,000, $50,000, who knows? And their perception is, and this is their perception, but we need to be concerned about their perception, that what they paid for didn't get them real value for money, didn't get them a resolution, a meaningful and timely resolution, access to justice. We also have some interesting studies being done now on the impact of legal representation. And there are only a few of them so far, so this is not dispositive, but I hate to tell you that those early studies are showing that people who represent themselves versus people who have a lawyer for a day in some of our magnificent, and they are incredibly, well-intentioned duty counsel schemes, those people don't necessarily get better results. Another thing that we're beginning to see through some of the studies that are being done on self-representation is that there is a very strong assumption that self-represented litigants take up so much court time. And believe me, I'm quite certain everybody in this room could give me at least half a dozen examples of where that did happen. But the data that we have from the studies that are being done in the United States, where this is the same issue, show that, in fact, self-represented litigants do not take up more time than people who are represented. So, there are some interesting pieces to put into this mix to think about how far we just assume that access to a lawyer, access to justice means access to a lawyer. And the other thing that I think is important to think about in relation to this question is so many of the people who I have interviewed and have been involved in other studies talk about wanting to be part of this process with the lawyer. We have a model which in my book, The New Lawyer, some of you may know it. Oh, and by the way, Emma has 2 of them if anyone wants to buy one at my author's discount. There's a chapter in that book called The Lawyer in Charge Model. Talks about that as the pervasive model, that lawyers take over the problem for the client. They see themselves as being 100% responsible for moving it forward. It's a very traditional model of professional to client. It's a model that is no longer really working, as I've said already, for so many both domestic and corporate clients. So when we talk about access to a lawyer and legal services, maybe what we mean is not just 100% representation, 100% lawyer-directed activity. Maybe we mean something that looks more like an unbundling model. Maybe we need something that looks more like a partnership between lawyer and client in which there is a constant negotiation over what does the lawyer do and what does the client do. And certainly, that is one of the ways in which we address the next question, which is about affordability. What is our responsibility to those who cannot afford to pay for legal services? Now, I know that there are many of you in this room who have plenty of clients, and you do excellent work for them, and they will retain you in some cases over and over. But that doesn't change the fact that there are an enormous number of people in Nova Scotia and in Canada who cannot afford you. And I think that part of your commitment to access to justice is thinking about what that means for you, whether or not you have a full client slate, whether or not this is about enhancing your business. And by the way, I tell all my law students now, there's a niche business out there working with self-represented people who are desperate to give money to people. They just don't want to give a $10,000 retainer, and there may be, smaller chunks of it, but there's just as much money to be made out there if we structure the way we deliver those services differently. So what is our responsibility? How do we discharge it? We know that people want lawyers. One of the other things that was so interesting about this work I've just completed was that 86% of my self-represented sample, which was a very large sample of some hundreds, 86% of them had accessed or tried to access a lawyer. Some of them, half of them, had a lawyer working for them on a traditional retainer arrangement before they ran out of money. Others had gone to duty counsel. Others had gone to pro bono services. 86% of them. These aren't people who are saying, hey, I woke up this morning and fancied myself as Perry Mason. These are people who are saying, please help me. I can help myself a certain amount of the way, and we'll do that if it reduces the cost, but please help me. So how do we find ways to help these people? The obvious way to go is to think about alternatives to our traditional billing system. You in Nova Scotia have just passed a provision that allows lawyers in Nova Scotia to unbundle. So have most of the other law societies and bar associations in the United States. But I have to tell you this, almost nobody is unbundling, because it's still seen as one of those iffy, kind of squishy, maybe not. If I've got a regular client, why would I want to go there? Because it's different, and it is different, and it is complicated to do this. Absolutely. But here's the thing. My 259 self-represented litigants in my study, virtually every single one of them described to me, and I didn't give them this language because they don't have this language, but they described to me the process of seeking unbundled services. They talked about getting out the yellow pages and calling 20, 30 lawyers. And I can tell you that when they found no as the answer, they were totally baffled. They weren't angry so much as perplexed. I'm trying to give money to these people, they say. I would like to pay for a lawyer to sit with me and go over my file, to come with me on Tuesday morning for 3 hours to court. Now, I know for all of you, believe me, I understand this. I've been talking to bar associations about this for a decade. There are all sorts of difficulties around changing and adapting, not minimizing the ethical issues here, not minimizing the insurance issues here. But this is what I feel like I need to say to you and other law societies now. Get over it. You know, we have to get over it. We have to start adjusting to what people say they actually want. Of those 259 people, 12 got unbundled services. And about half of those were people who went back to their former lawyers. So, you know, in some ways, that wasn't a true unbundling. Another thing that I think we need to think about seriously here, and I know that in Nova Scotia you have actually started to take some steps to do this, is how we professionalize our pro bono services. You know, one of the real problems with the structures that currently exist of duty counsel, summary advice models, pro bono organizations offering assistance to people is that they're seen as a place for young lawyers to cut their teeth. They're seen as a place where people go to get experience rather than where people specialize. And you know what? The general public knows that. They have figured that one out. And so I would urge you to think about supporting a specialized, really effectively trained pro bono element in your profession, which doesn't necessarily mean that you participate in it, but that you support it through the medium of training that is specifically for that, which is about releasing senior lawyers to do that work at different times, which is about promoting the idea of loan forgiveness programs for lawyers who want to do this work. There are all kinds of ways in which each of you as a member of a law society can promote the idea of professionalizing specialized pro bono services so that they're not just the sink pit, because the people who work in them really do deserve your support. So what about technology then? This is usually the moment at which the PowerPoint explodes, you know, that would be kind of. How far is access to justice achieved by technology? You know, the reason that I did this study was because when I started to look at the enormous rise in the number of self-represented people, up to 80% in some family courts, 40% in first instance civil, it's the same here in Nova Scotia, I realized that the policies that we were putting in place to deal with this were almost exclusively about providing more online and web-based resources. Now, that's not a bad idea. In fact, it's a pretty good idea. But here's some of the problems. A lot of those web-based resources are still very primitive. They're essentially somebody vomited the rules of civil procedure onto a web page. That's not terribly helpful for somebody trying to navigate this. It's not terribly helpful for a lawyer sometimes either, for that matter. So there is very little that is specialized for self-represented litigants yet. Another problem, there is still in the online forms that are now available in every province pretty much, all kinds of legal technology and jargon. They are enormously complex. I assigned one of my student researchers on the project last summer to apply for a divorce, not get a divorce, apply for a divorce in the 3 provinces that we were working in, BC, Alberta, and Ontario. She was thrilled. Her boyfriend was a bit concerned, but she was thrilled because this was going to be a real practical project that she could have. She just finished civil procedure and family law, and she was like, yes, yeah, good to go. I told Kyla to keep a log of every minute she spent online and everything that happened. She came back to me about 3 weeks later on the verge of tears. I was actually going to assign her to go and do the same thing in small claims court, but I didn't have the heart to do it. I can't do this anymore. as someone who was legally trained, she found vocabulary, Latin vocabulary she couldn't understand. She would complete a form that took her an hour and a half, and then it would vanish off the screen. She would go to a URL that was going to give her information, and the URL link was broken. She would complete a form and then realize it wasn't the form she was supposed to complete. She needed to complete another one. There is an enormous amount of work to be done to make these portals work properly. And I believe that that work is going to be done and should be done. But in the meantime, I think you need to be aware of two things. One is that all of this information on the internet gives people a false sense of confidence going in. And it really does. People talk about that all the time. I thought it was going to be so easy. There's all that stuff. And secondly, it doesn't provide them with a face-to-face experience, which is what so many people need. I mean, this is one of the reasons why lawyers are critical in access to justice still. You need to be part of that face-to-face experience. Simply talking to the computer, even in the occasional interactive program which is emerging, it's just not enough. People need a human face. However, maybe they don't always need a human face who's a lawyer. And this is my fifth and final question. What is the role of other professionals in providing legal services, and how should lawyers collaborate with them to provide access to justice? We have to ask ourselves this very tough question. What kinds of legal services, think of the work that you do, each of you, absolutely require a qualified lawyer to carry out? Is there an aspect of what you do, or perhaps gets delegated to somebody else in your office, that really doesn't need the imprimatur of a qualified lawyer? And I would suggest there are two kind of categories here to think about. One is about the difficulty and complexity of the task. Self-represented people and clients in previous studies have always complained that they think that paying $350 an hour for somebody to fill in a form, even if it is a really hard form, is too much money. So part of this is about the complexity of the work. What requires a qualified lawyer, what doesn't? We have this legal information handcuffs out there at the moment on people who are working to provide legal information in court-based services all over Canada. They work incredibly hard, they're under enormous pressure, and they are in handcuffs. They are in handcuffs because they are terrified they're going to do or say anything that will be legal advice. And in that dubious distinction, which I think those of us who are long in the tooth find a very dubious distinction, what we've done is we've defaulted to everything is legal advice. Legal information is this tiny, weeny little bit. And we need to change that. We need to reset that default and free up people to give legal information. And to be clear, talking to somebody about how to fill in their form at a courtroom counter is not the unauthorized practice of law, people. We don't need to overreach in this. There's plenty of work for lawyers to do. It doesn't need to be that. The other part of this debate, of course, is paralegals. What can paralegals do? What should paralegals do? And, be proactive about what you want to set as the standards. The Law Society of Upper Canada now regulates paralegals. There's a lot of controversy about that because they don't let them do any family work. To give them credit, they are currently studying what parts of family practice require a qualified lawyer. They are asking that question. And again, I think you should be proactive about that because and some of you will know this, I certainly know this from the last year and a half spent in courthouses across Canada. There are lots of people out there running around the courthouses saying, I'm an experienced self-rep, pay me $50 an hour and I'll help you. I mean, it's kind of like the internet. It's happening anyway. We have to be able to respond to it, not just let it happen to us. I think that we need to have a really serious debate about intelligent priority setting here. What are the services that we absolutely need lawyers to do and to which they bring value? And I believe there are many ways in which lawyers bring value. That's what the new lawyer is about. But I think that we need to start setting those priorities intelligently and not just assuming the whole territory. So, in conclusion, how can each of you engage with this idea of access to justice? 3 suggestions. Innovate. I know, it's so hard to do that. You're probably thinking, God, I've only got about another 10 years left. Really, do I need to be messing around with this? I sympathize. But you know what? It's here. As I said about unbundling, we need to get over it. And your society will support you and help you in that innovation. It's not enough for the society to say, we permit you to do unbundling. The society needs to be going out and teaching people how to do it, having a conversation with new lawyers about how to do it, because they haven't got a clue. Share the territory. There's plenty of disputing out there, believe me. And there are plenty of other professionals who can be part of this, and which, if we are smart, we will collaborate with and make partnerships with. It doesn't mean that we have no territory. It means that we take a unique niche, which is what the lawyers of the 21st century need to do. It's not the territory that we took in the last century. It's not the work that we did in the last century where everything was adjudicated. It's a different kind of work, and we need to claim that niche and share the territory. And finally, commit to the public. You know, I really do believe that, oh, well, you saw it, it was there. I really do believe that lawyers need to say that they are committed to everybody, for you in Nova Scotia, whether or not they can afford legal services. I think that that is part of our public responsibility, and I think that there are many people who share that vocational aspiration in the practice of law, and I would encourage you to continue that commitment. Thank you very much.
Sure, move along. Absolutely, I think so. I'd invite